ask you to tell us about the vision you have for the Court of Appeal and what values you want to bring to the Court of Appeal in terms of your experience, in terms of your knowledge and skills. Generally, you know, we are struggling with the backlog of cases there, and what things you are going, what are you going to introduce there to deal with the backlog, to reduce the backlog of cases there in the Court of Appeal? So those are like 4 or 5 questions which you can answer in 5 minutes.
Thank you very much, Chair. The Court of Appeal needs a competent judge. I will bring competence to the Court of Appeal. And when I talk of competence, I mean a judge who has sound legal knowledge, both substantive and procedural. Chair, we know we have over 500 statutes in this country. So when I talk of sound legal knowledge, I don't mean that a competent judge knows all these 500 statutes as well as judge-made law. So in this respect, I would propose that a competent judge needs to have analytical skills, research skills, so that when they are dealing with new areas of law, they know how to analyze the facts which have been placed before them, interpret the law, and apply the law. A competent judge is a judge of integrity. The Court of Appeal needs judges of integrity. And when I talk of integrity, I'm talking of honesty, I'm talking of high moral standards. The Court of Appeal needs a judge who is a performer. Honorable Chief Justice and commissioners, my record speaks for itself as far as performance is concerned. I've emerged tops 3 times, the stations which I led in PMMU. And last year, I was recognized as the most consistent performing court in the ELRC. The Court of Appeal needs a team player. I believe I'm a team player, and I will be able to fit in within the fraternity of the judges of the Court of Appeal. Honorable Chief Justice Commissioners, I've acquired experience in the Employment and Labor Relations Court since 2012. I'm a member of that inaugural court, and I think I can confidently say that I'm a veteran judge of that court. I've acquired skills, experience in the employment and labor relations field, and I believe that the Court of Appeal would be the richer with these experience and skills which I have acquired over the past 13 or so years. Thank you, Honorable Chief Justice.
Very much. Commissioner Mwansa will take us to the next level.
Oh, thank you. Judge, just want to interact a bit about this competent judge. And one of the key attributes of judgecraft is something that is known as judicial courage. Perhaps, Judge, you can tell us what are the key aspects with respect to judicial courage, and if in your, as a veteran judge, you can give an example of two where you've been able to exhibit that attribute.
Thank you, Commissioner. The first attribute of a courageous judge I can discuss is impartiality. What I mean by impartiality is that you must be free of influences, whether they are family influences, friend influences, colleague influences. The second attribute I would talk about is being faithful to the doctrine of the rule of law, meaning that whether it's a big person in society, it's the woman from Siaya who doesn't know any law, who cannot speak English, you must treat them equally. Independence is another attribute of a courageous judge. The courageous judge must be ready to do his work without fear of political pressure or any other external pressures. Commissioner, I think those are the three which I could discuss now. As far as my experience with being a courageous judge,
Yes.
the case which comes to mind is the Kiambu doctors' strike. This was late last year, from middle of last year up to December last year, when they reached a consent. The doctors were insisting that the county government of Kiambu was not treating them well, that the county government of Kiambu had given them promises. They had signed return to work formulas which were not being fulfilled by the county government. Then the county government came to court to seek for an injunction. And they were saying, you are in the essential service, you cannot go on strike. I refused to give that injunction. Reason? Because when I looked at the history of the disputation between the doctors and the county government, I was seeing a long chain of unfulfilled promises on the part of the county government of Kiambu. And we all realize that with the doctors on strike, medical services are affected, health services are affected, but at the end of the day, the doctors also are entitled to certain rights. Thank you, Commissioner.
Thank you, Judge. Now, you appreciate that the Court of Appeal is a court that handles appeals from all the superior courts, from the specialized courts and from the High Court. And I'd want to ask you one or two questions about the offense of piracy. Now, there is a case that arose in Mombasa, and it was tried under the Penal Code. Let me read for you the particulars of the offense that was set out in the Criminal Code. It stated that on the 3rd of March 2009, upon the high seas of Indian Ocean, near the Gulf of Eden, jointly being armed with offensive weapons, namely 3 AK-47 rifles, 1 pistol, 1 RPG, portable rocket launcher, 1 SAR-80 rifle and carbine rifle, attacked a machine sailing vessel, MV Courier, and at the time of such act put in fear the lives of the crewmen of the said vessel. So the accused people, or the accused persons, 9 of them, were arraigned before the Chief Magistrate's Court in Mombasa, and they were charged with the offense of piracy, then under Section 69 and 92 of the Penal Code. They pleaded not guilty. There was a trial. 15 witnesses tendered their case, and the prosecution closed their case. Thereafter, they were put on their defense, and at the point whereby the court retired to consider the evidence and deliver judgment, they proceeded to the High Court under judicial review, seeking to quash the proceedings on the High Court on the principle that the offense happened outside Kenya's territorial waters, and that Section 5 of the Penal Code restricted the jurisdiction of the magistracy to try, or the magistrate court to try offenses within Kenya's territorial waters. The High Court agreed with their submissions and quashed and further prohibited the trial or the court from proceeding further. This matter now has come before you as an appellate court to determine whether there was an error that had been committed by the High Court, and whether indeed the magistracy has jurisdiction to try an offense that is known as piracy jure gentium. I would want to hear about your views about this issue.
Thank you, Commissioner. The Latin maxim you've used, I'm not aware of.
It means piracy affecting the nations.
When there was a lot of piracy along the Somali shore,
yes,
I recall that Norway or one of those European countries arrested pirates and went and charged them somewhere.
yes,
So I want to believe that piracy is a crime against all of us, against the whole world. Now, the question which I think might be labored is, these pirates, they attacked which flag carrying ship?
they attacked a foreign ship, which was, it's not a Kenyan ship, it's a foreign ship, and it was not within our territorial waters. It was at the Gulf of Eden.
So the countries which would have jurisdiction would be the flag where the ship is registered.
Yes,
That's number one.
yes,
The nation where the pirates come from. And I believe piracy is a crime against the whole human race. So the High Court definitely was wrong in quashing the decision of the magistrate to assume jurisdiction.
Okay.
I would overturn the High Court.
you are right up to that point. Based on what principle?
The principle which I would use is that piracy is a crime against all of us.
Yes,
I think universality is a universal crime.
yes, the principle of universal jurisdiction.
Okay, sorry. Universal jurisdiction. Thank you.
Yes, thank you, Judge, and that's it.
Thank you.
Thank you so much, Honorable CJ and Judge. Once again, welcome. I want us to have a look at the issue of public participation. This is an area which, no doubt you're aware, has seriously been litigated on, and we have adequate direction from our apex court. Now, I want you to look at a public entity. Let's look at a public entity and the nature of decisions which are made in this public entity. Two types of decisions. Decisions which impact on the day-to-day internal operations of that entity, day-to-day internal operations of the entity, and on the other hand, decisions which transcend the internal operations of the entity. Now, should both kinds of decisions be subjected to either public participation or stakeholder engagement, and why?
Internal decisions would be subject to public participation as well. And I would give an example which has been going within the judiciary. The petition on removal. Because that one essentially relates to us, but the complaints come from outside. So when we are preparing those regulations, we must invite our stakeholders to come and give their views and participate.
So is that an example of decisions which transcend the internal operations, or the other one?
Transcend.
The transcend.
Transcend.
So your answer is, for decisions which transcend, public participation, stakeholder engagement is necessary.
It's necessary and
Thank
it's
you.
a must.
Thank you. The other side?
For the internal daily operations, I do not think that we will require the public to come and tell us. But again, when I reflect on it, again, I'll give an example. We have CUCs, we have bar bench, we call them very often to discuss with them our daily operations. So even on that other respect, I think public participation may be called for.
When you are dealing with issues on the daily operations, day-to-day decisions, why did you come late to the office? I need these files to be at this place and this place. You think we need public participation on those? Those decisions which assist us in the daily running, they actually do not per se impact on the outside of the institution.
When a judge starts court at 9:30 instead of 9, and it becomes persistent, I know the partners, the stakeholders will raise it. So I think it's something which we must be ready to listen to them and accommodate their views.
Okay, Judge. Thank you. And I think the last one here is this. It's on the jurisdiction of the Court of Appeal. Judge, you're aware that there are instances where the Court of Appeal can allow the taking of further or additional evidence. The Court of Appeal has that power, it can. Now, in an instance whereby the Court of Appeal is satisfied that this is a case where additional or further evidence needs to be taken, does the court proceed to take that evidence itself, or it has to remit it to the trial court?
The Court of Appeal, under Section 3(2) of the Appellate Jurisdictions Act, has the authority and power of the High Court. It can proceed to take the additional evidence. It can also remit that process to the trial court, the High Court, or it could even refer that to a commissioner. If you look at the rules, it refers to a commissioner. So the Court of Appeal can take the additional evidence, it can remit to the High Court, or it can give that task to a commissioner.
Thank you so much, Judge. I wish you the very best. Thank you.
Yes. Judge, you are appointed to a newly established Court of Appeal station and designated as a duty judge. An urgent ex parte application is placed before you under Rule 5(2)(b), seeking stay of execution of a High Court judgment. On the face of the record, the application appears arguable and the nugatory aspect is demonstrated. Would you grant the order ex parte as prayed? And if yes, what considerations would guide your decision given the exceptional nature of ex parte relief at the appellate level?
I would not grant an ex parte order under 5(2)(b).
Thank you. The Court of Appeal is fundamentally a collegial court, isn't it?
Yes, it is, Commissioner.
Could you identify 2 categories of matters that are properly within the jurisdiction of a single judge of the Court of Appeal?
An application to extend time under Rule 4 and a reference from a taxation. And I believe a third one would be an application to withdraw an application.
How does the mechanism, no, what is the institutional rationale for allowing a single judge determinations within a collegial appellate court structure? If it is a collegial court, what is the rationale of allowing a single judge to exercise jurisdiction in some instances?
I would want to assume that one of the rationales is expedition. Expedition, and the application is on a procedural issue, which does not raise any complexities of law.
Now, what remedies are available to a party aggrieved by a decision of a single judge of the Court of Appeal?
The party can make an informal application for a reference to a bench, or can also file a formal application.
And finally, how does the mechanism for reviewing single judge decisions reinforce both accountability and collegiality within the court?
We are all prone to error and making mistakes. There is a saying where I come from that 2 hands are better than 1. So if I make a mistake, there is an error, I think it's open to my brothers and sisters to have a look at it, to assure themselves that what I did was right or wrong. So it does not affect the question of collegiality. Because for me, collegiality is not a question of this judge is right, this judge is wrong. It's a question of how do we appreciate the law. If I get it wrong, let it go to the full bench or an expanded bench so that they can assure themselves that justice was done.
Okay, let me ask you a supplementary question to those then. You've heard of autonomous artificial intelligence?
No.
This is artificial intelligence which does not need the guidance of a human being. It can act by itself, step by step. It can move itself, collect, give decisions. You've heard about that? The
No.
third generation AI?
No, I think the AI I've heard is chat something, and I've not used it, not yet.
Okay. So you need to learn about it. Now we have autonomous AI now, which is able to move itself, does not rely on a human being to move. And as artificial intelligence systems are influencing human conduct and behavior, we find that there are some activities. In criminal law, we have the actors' rules and the mens rea. So there are some activities that the artificial intelligence mechanism or systems can undertake without the knowledge or the prompt of the owner. For example, if you always buy beer every Friday, your system can learn you and buy beer even when you don't have money, and you be charged with obtaining by false pretenses because you don't have the money. If you are a doctor in a hospital and you're using artificial intelligence and you give medication to a certain patient in ICU, if that patient is not there, the artificial intelligence might give the same medication to a different because of the systems. Now my question is, this is affecting criminal law. How should the criminal justice system conceptualize and assess mens rea, where harm results from AI-assisted or mediated actions, particularly in determining attribution of intent or negligence between the human actors? The human actors would be the people who have employed the AI, the system designers, people who have designed the systems, and the state. And what role, if any, should appellate courts play in shaping principal standards in this evolving area? I hope we are together.
Within the criminal law sphere, and you've talked of actus reus
And mens rea.
I don't think I would envisage a situation where we are using AI to tell us that there was actus reus or there was mens rea. I don't envisage such a situation. If we were to go that way, would be
I can give
treading-
you another example. In the banking sector, they now use AI, and sometimes you might find that across the board they deduct people's salaries of the same amount, and they can affect your account and affect your further availability of money. You find your salary has been deducted, maybe it was not supposed to be deducted because the machine acted across board, isn't it?
Yes.
Supposing the person who did this did it with a view to steal, which they are doing sometimes, so it would be AI assisted.
Thank you, Commissioner. Still proving that element of mens rea will be extremely difficult. Why do I say that it will be extremely difficult? The AI tool, I've had something called algorithms.
Yes.
The person who prepares or installs those algorithms might not be the person who is using this tool to steal my money. So where will we now prove this element of mens rea?
Those are the complexities of criminal law, and that's why I'm soliciting your mind on what we can do to respond to such, because it's actually with us.
If I simplify it, I know we have something called two-factor authentication. So some of these things, we have measures which would ensure that the machine or the AI does not automatically do what they do without the authority of somebody, either the owner of the system or the bank manager or the approver in the bank. So it will be a challenge. It will be a challenge, but the world is really moving at a fast speed technologically. Perhaps it's something which we might need to consider.
So as you go to the appellate court, just take time and acquaint yourself with some of these things, because we'll soon be before you with subject matters affected by autonomous AI.
Thank you, Commissioner. That's why I said when I was introducing myself, you must have these skills to analyze, apply, and interpret. Because every day we come across very new areas of law. I'm ready to learn.
Thanks. And as we come before you, you also appreciate the challenges the law enforcement will go through when investigating such matters.
I do.
Because the evidence is not tangible, like what we are used to, and the scene of crime is not on earth, sometimes it's in the cyber world. So we will accommodate each other.
I appreciate.
Thank you.
Thank you very much, Chief Justice. Judge, a few questions from me. A litigant is before your court, and you've determined their matter, and they are not satisfied with the outcome that you have made. They subsequently file an application for stay before your court. You consider that application and you find no merit and you dismiss it. You do not grant an order for stay. How should this litigant thereafter proceed, him or she still being desirous of getting an order of stay?
I do not think that an application under 52B is appealable to the apex court. So as far as having another bite at the cherry of going to the Supreme Court, that is closed to them.
Say that again.
As far as having another bite at the cherry, because they are dissatisfied, have rejected their application for stay, they cannot go to the Supreme Court, because that's an interlocutory application, a ruling on an interlocutory application.
Supreme Court?
I'm in the Court of Appeal.
No. Sorry. You are still where you are.
Okay.
You're not yet in the Court of Appeal, but I wish you the very best.
Thank you.
You're still where you are.
Yes.
Yes.
Now, it's always open to a party who has not been successful at the level of the High Court or the co-equal court to move to the Court of Appeal for a stay, even if it has been rejected by the trial court. That's open. So one avenue is to go under 52B to the Court of Appeal, or they could as well come for a review.
So in terms of approaching the Court of Appeal, how do they go about it? They file a fresh application, or what exactly happens?
The jurisdiction of the Court of Appeal under 52B is a special jurisdiction. I know some have called it an original jurisdiction. I would rather call it a special jurisdiction. It will be a fresh application.
So is it also open to this litigant to file an appeal against that decision that you made in that ruling, refusing an order for grant of an order of stay?
That's not open. You cannot now take it both ways. You must choose one option.
But can you choose either?
No, you cannot choose either.
I think that's something that you will need to check. Whether you cannot file an appeal from a decision that you've not been granted an order for stay. One way is to go to the Court of Appeal by a fresh application, and then the other route is, of course, to file an appeal, which I think that's something that you can then check on. And I appreciate what you said, that really when you come for an interview like this, it's not expected that you know everything. But again, how do we differentiate who understands the law, the substantive law, who understands the procedure? And that is why we must do what we are doing.
Thank you.
Now, under the rules, and in particular Rule 102 of the Court of Appeal rules, when does an appeal abate?
An appeal will abate if the appellant, being a natural person, dies. An appeal will abate if the respondent, being a natural person, dies. Those are the two scenarios I can describe.
So a natural person has died. Is that the end of that appeal?
Yes, that's the end of... No, that's criminal. I think that's criminal. That's criminal. That's criminal. 102 should be civil. For civil, a legal representative should come in within, I think, a period of 1 year. If they don't come in, then it will abate.
All right, you're right that they must come in within a period of 12 months. Supposing the 12 months elapse before they have made an application wanting to be substituted as the representative of the deceased.
They can come for leave. And I'm saying this because the reality in Kenya is that sometimes it takes a lot of time to get those letters of administration. So it's open to them to seek leave, to have that appeal reinstated.
All right. That is correct. Now, we hear of expanded benches of the Court of Appeal. How are they constituted? Who moves the court? What happens before an expanded bench is constituted?
The initial members of the bench could be moved by any of the parties, and they would refer this to the President of the Court of Appeal to constitute this expanded bench. And I believe that there must be very good reasons. For example, if there is a conflict in decisions coming from the Court of Appeal and they want some clarity. But essentially, at the end of the day, it's the President of the Court of Appeal to constitute an expanded bench.
Can you write to the President directly and request him to constitute an expanded bench?
Yes, it's open to a party to write to the President of the Court of Appeal, inviting him to consider constituting an expanded bench.
All right. I mean, being a judge of many years' experience, and even then, before then, having been in legal practice, I do know as a fact that you know what a decree is, isn't it?
Yes, I do.
Yes. Now, in compiling a record of appeal, is it fatal if a decree is not part of that record of appeal?
I have seen a decision from the Court of Appeal saying that the decree can be introduced through a supplementary record of appeal, so it would not be fatal.
Has this always been the case, or was it different some time back?
I think during my youth, when I started practice, if you didn't include a copy of the decree, your appeal was a non-starter.
Yes, I think I can identify with that, whereby as advocates we would go to the Court of Appeal in Nakuru, and the judges would have a very long cause list, but all the appeals would be dismissed because there was no decree. Thank you.
Thank you.
All.
Yes, you have a matrimonial cause before you, and the petitioner says the marriage has broken down and is asking you to divide the matrimonial property. The respondent says, I'm not married to this person. I'm not married. We know each other. We have lived together, but we are not married. What parameters would you apply if you were to check, if you were to apply the presumption of marriage test?
For how long have we cohabited?
Yes. What else?
What impression have we given to the society about our relationship? Commissioner, I think I will...
And if one of them is married already to another person?
It will depend under which regime of law that marriage was contracted, because we have customs which allow polygamous marriage. So if it was under the Marriage Act, the civil one, or under the church is monogamous, I think it would be very difficult to presume that now my second person was also a wife for purposes of this. But if it was...
What if the petitioner is the man and the respondent is the woman saying, I have another husband. I have a husband, not another one.
Polyandry, is that what is called polyandry?
Can you presume a marriage in those circumstances?
In such a circumstance, there would be no marriage.
There would be monomarriage. Thank you. What do you know what the burden of proof is for one to prove that they are married in those circumstances? The burden of proof lies with
the person who is asserting.
And what is the standard of proof?
Balance of probabilities.
Okay. So assuming you make the finding that they are indeed married, you presume the marriage, and you come to the division of matrimonial property, what would you take into consideration when dividing matrimonial property?
Contribution.
Of what
direct
kind?
And indirect, financial and non-financial.
Can you give me an example of a non-financial contribution?
Home care, bringing up the children, housekeeping.
Is giving birth to children a possible contribution?
It is.
Okay. Assuming then we leave that scenario, and in fact you have found they are not married, that they have not met the parameters for presumption of marriage, but they own property together. What remedy is available to them? Because it's not you cannot divide it under the matrimonial property legal regime. So what remedy is available to them as a couple living together but who are not married, but own property together?
I would invoke the law of contract and land law.
Okay. Thank you
Yes.
very much.
Thank you.
Good evening once again, Judge.
Good evening.
Would you want to drink water or you okay?
I will drink water, though I've taken
Please,
two of
please.
these outside there.
Okay. Okay, thank you. I've gone through your sample writings. All of them are linked to your court, employment and labor. They reveal strong analytical competence, and across the judgments and ruling you provided, you consistently demonstrate an ability to clearly identify issues, relate facts to applicable legal principles, and reason through disputes in a structured and coherent manner. Two cases, that's the university dispute and the trade union matters, you advance jurisprudence by interrogating the exercise of discretion by statutory bodies and insisting on lawful, rational, and equitable processes. You exhibit judicial restraint and doctrinal clarity, especially in jurisdictional question where you apply textual and formal approach to prevent overreach. So they show a balance of purposive interpretation and doctrinal discipline reflecting maturity in decisional judicial reasoning. So I must commend you for the good job you have done with these first 5 sample writings. I hope you also write the same way in other decisions.
Yes.
Okay. You were a president of the Kenya Magistrate and Judges Association for some time. And there is this saying that goes, culture eats strategy for breakfast. So there's been extensive judicial transformation plan over the years, but there is this feeling from members of the public that we are not there yet. What aspects of judicial culture most undermine reform? So this is more inward looking within the judiciary. What culture is making it impossible for the judiciary to be where Kenyans are aspiring it to be? And how, as a judge, can you influence the change of that culture?
Thank you, Commissioner. Kenyans want expedited determination of cases. That was a big problem 2024 and part of last year. And I believe that is what led the Law Society of Kenya to go to the airwaves to demand that we have structured trainings for judges so that we can sit in our courtrooms and hear and determine cases. I believe that issue was discussed and resolved so that at some point there was a pause on the trainings before everything became regularized. So that is number one. Number two, another culture which I think we need to work on is timekeeping for judges and judicial officers. Many a times, courts do not start on time, without explanation, without notices to the litigants, to the advocates, and other stakeholders. I believe that discussions have been had on this, and unless there are special circumstances, currently every judge, every judicial officer must give at least 7 days notice if they are not going to sit. Again, if a judicial officer or a judge is going on leave, we were not informing the litigants in good time, at least 1 month ahead, because leave is planned. You know when you are going on leave, 2, 3, 4 months before you proceed on leave. So these days, we have changed that culture. we give those appropriate notices that court 1 or court 2 is going on leave. So I believe that as far as institutional culture is concerned, we are not doing very badly, or we are not where we were in 2023 or 2024.
Okay, thank you. So the World Economic Forum Global Risk Perception Survey 2024 lists several top risks the world is facing. 1 is misinformation or disinformation. 2, extreme weather patterns. 3, deepening social divide. 4, cybersecurity. And 5, geopolitical instability. How are courts expected to consider all these things when determining disputes?
Thank you, Commissioner. Kenya is a signatory to international treaties and conventions which regulate some of these areas, like climate. And if you go to Article 2 of the Constitution of Kenya, there is a demand that when we are dealing with these issues, we must take note of the conventions and treaties which we have signed or ratified, and as well apply the rules of international law. So we cannot run away from these realities of globalization, because there is a demand from the Constitution in Articles 2, 4, and 2.5 and 2.6 that we must take cognizance of what is going on in the world where we have made commitments.
Thank you. And the thing you are saying, chat something, it's chat GPT.
Thank you.
And it is not bad to use it, but there are certain parameters where you are expected not to use it. So I think it's important to have a governance document around AI as a judiciary and judicial service commission. Thank you, and all the best.
Thank you.
Now that Commissioner Inguti has given you the answer to the question I wanted to ask, I have to think of another question. So, what is your view, Judge, on the carrot and stick approach to performance management or evaluation? Is it good or bad? The carrot and stick approach.
We all know the performance parameters. We've all been inducted into the performance measurements in the judiciary. So if I find that consistently you are not performing, I would not hesitate to use the stick. But again, if there are any challenges which you are facing, we will discuss them. But if I've been performing consistently well, I think I deserve the carrot. And we've not done very well in the judiciary as far as the carrot is concerned.
I was actually coming to that, but now you can expound. Since you've made that statement, why do you think we're not doing very well in terms of the carrot?
For me, where I sit, I understand. We conclude the PMMUs, the best performers are announced, and they are promised their Kenya shillings 150,000. That money never comes until 1 year later. It is a demotivating factor. Number 2, we have not yet started to recognize and reward individual performance. I know it's in the HR policy, but I've not seen any recognition or rewards. So I believe that's an area where we need to give the carrot to those who deserve it.
Judge, in your view, is financial reward the only worthy carrot?
For a normal human being, what goes into the pocket is a very big motivating factor. But what I'm seeing is we are not even giving certificates to recognize those who have performed. We have staff in the registry, We have JOs who have performed well in various areas. It could be case clearance rate. We just mention it, but we don't even give them a certificate to say, we recognize your effort, we recognize your performance. So I believe there is room for improvement there. It's not only the financial reward.
Okay, I agree with you in that respect. But there are also ways in which I think as an institution, we are still providing the carrot, giving opportunities for career progression. That's another way of giving a carrot. We are probably having this conversation with you because of the report we have on you from DISPOP. I don't know if you've seen it.
Yes, I've seen it.
I'm saying we are probably having this conversation because in terms of shortlisting, this was one of the factors also we were considering, whether the candidate is a performer or not. So that is a carrot. You can consider that a carrot. But we can now have a discussion with you around your performance. And I would say it appears you've been consistent in terms of posting your results. I'm comparing this to what has been said about you from our background checks. I see here the expected resolution from you was 4.2%. There's 12 of you in your division.
Pardon?
There's 12 judges in your division.
In Nairobi?
Yes.
No, we are 6. We are 6. 12 is the whole complement. Those in the appeals division?
Yes, that is what they were considering.
Oh, okay.
So there's 12 of you. The expected resolution was 4.2%, and from this report, you are doing 4.6%. So you are exceeding expectation, and I think that's commendable. I wish you well, Judge.
Thank you.
Thank you. Thank you very much, Honorable Chair, and welcome again, Judge.
Thank you.
Now, I'm sure you are aware of the budgetary constraints in the judiciary, and perhaps that is why the judiciary is unable to provide the carrot.
Yes, I'm aware.
So, how will you balance this, how will you balance the constitutional imperative for expeditious justice with limited judicial resources?
Thank you, Commissioner. Currently, luckily, we are using technology to conduct most of our court sessions. That's the virtual courts. And I believe that one has gone a long way in obviating the need for creating physical infrastructure like courts everywhere. In fact, through Mahakama Popote, you'll find a magistrate in Busia handling matters from Mombasa. So I believe that's a godsend for us, that we can harness technology despite the lack of resources or enough resources. So that's a plus for us. Then number two, most of the advocates these days file their pleadings electronically.
Okay.
When we started this, they would send them through email and we have to print them. That's no longer necessary because all those pleadings are available there on the CTS. I think that's also addressed this issue of resources. The third one, which I can talk about, Honorable Commissioner, is that for some of the trainings, these days we accept even half per diem. We don't insist that we want the full per diem. Like the IMJA, which we held in December last year. Those who attended were not paid the full per diem, and they did not insist that we want the full per diem because we understood the lack of sufficient resources. So again, we are called upon to understand some of this, but at the end of the day, if the resources are there, I believe it will only be right that we insist that we get what is due to us.
Okay. Okay. Now, what is your view on consensus building, and how do you balance consensus building with decisional independence and collegiality?
Human relations can be complex and difficult. So for one who is working in a collegiate court, you must first of all work on informal relationships with your colleagues. Informal, not to the extent that you become too used to other, that when a suggestion is made for consensus, you just say yes, but informal so that if there are mutual discussions which are necessary, when I approach you and I tell you this is my view, you are ready to listen to me, you are ready to be convinced, you are ready to be persuaded. But consensus by itself should not mean succumbing to other opinions. So if consensus cannot be reached, I believe that the law allows that we can do our different rulings and judgments. But for me, the starting point is creating informal relationships with those you work with. With those informal relationships, they will know my challenges, I will know their challenges, and that makes it very easy to gel. But as the former Chief Justice used to say, at work you don't have to like or love your colleague. Thank you.
Okay. You earlier on you spoke very passionately about your integrity, but I would wish to know what your colleagues or even the stakeholders say about your integrity. What do you think they say about your integrity?
Like Caesar's wife.
Okay. Very well, Judge. I think they have not raised any issue on your integrity, according to the feedback that we got from the stakeholders. They actually they've given very positive views on you. They say you are a good timekeeper, you deliver judgments on time. However, there are some who have said that you have issued inconsistent decisions. There are some inconsistent decisions that were raised, where it was said that you apply the same law differently and will depart from your decisions. For instance, in two matters with the same respondents, you said it was said you dismissed one with cost and the other one you dismissed without costs, without giving details. So how do you respond to that stakeholder or those stakeholders?
Thank you. Costs follow the event, but at the discretion of the court. And before the court exercises this discretion, there are several factors the court may want to consider. One is the conduct of the parties. If I feel that a party was trying to cause delays, sometimes I will not award costs. Commissioner, as a general rule, and as part of my docket management, I give timelines. I ask you, please file your submissions by this date. If you don't file, I never give costs. And I believe this was a big issue when I was in Kisumu, and Commissioner Ngotia is aware of this. But it helped to straighten things, to keep advocates on their toes. So it will depend on how you've conducted yourself during the proceedings. You will succeed, but I'll not grant you costs because you did not help me to achieve the principal objective of the court.
Okay. Thank you. Thank you very much, Judge, and I wish you all the best.
Thank you.
Thank you, Honorable CJ. Justice Radido, I have a few questions for you. The human resource is one of the biggest assets in any institution. And if you're successful, you will be in charge of this very important asset. Could you please give us 3 key personal attributes, only 3, that you possess that you feel will drive this institution forward in matters human resource management?
The first attribute which I can talk about is that I'm a team player. And this has been exhibited even under my leadership of the association. When I took over the leadership of the Kenya Magistrates and Judges Association, it was during a very turbulent time for this institution. Commissioner, you will realize that we reached out to this same commission to discuss many of these outstanding issues. And I believe that as a team, the commission on that other side, the executive council of the association the other side, we managed to gel as a team and we achieved so much. That's number one. The second attribute as far as HR is concerned is respect, mutual respect. You must respect the very lowly employee, and you must also respect the very high employee. And some of these are exhibited through very normal things. In the morning when you are coming in, good morning, you greet them. They feel appreciated. So that interpersonal relationship with all employees, despite their level in the organization. The third attribute which I would want to talk about as far as HR is concerned is I'm easily accessible. Any member of the judiciary will tell you Judge Radido is easy come, easy go. He operates an open door policy. He is ready to listen and give advice and mentor. I'll give an example without mentioning names. When I was in Kisumu, we had a particular gentleman who had a serious problem. A judicial officer. He went to so many people. But they were all telling him, please go and talk to Judge Radido. So I'm open and easily accessible.
Okay.
Thank you.
Okay. As president of KMGA, how did you handle situations where you disagreed with colleagues but ensured you maintained mutual respect and confidence?
Thank you. The association is an association of judges and magistrates. Many times the interests of the magistrates and the judges do not converge. So the first thing you must do is listen to the views of the others. Also give your views and then try to bring them to a consensus. And that is what I used as a leader, and that's why I can say without a doubt, a shadow of doubt, that we had a very successful tenure under my presidency, because I was able to bring together all these divergent interests.
Okay.
By sitting down, discussing, and agreeing.
Okay. Finally, from me, do you imagine you have any weakness as a person?
Of course, I must have a weakness as a person.
Please tell us one.
I'm a stickler for time.
How is that a weakness?
I'm a stickler for time, such that if we agree it's 9 and you come at 9:10 and you didn't have the courtesy to tell me, sometimes you find I've gone. So for me, I'm a stickler for time. Somebody might say it's impatience. He's not patient to wait. So I believe it's within that context.
So how are you able to balance that to accommodate the people you're working with? How do you go around it so that you also don't create this perception in people that you're an impatient person?
Thank you, Commissioner. I talked about creating these informal relationships. Once you create those informal relationships, you pick up the phone and call. We agreed we meet at 10. Where are you? Why are you not even having the courtesy to call me and tell me I'm late? So that's how I've dealt with it. I'll call you.
Okay. All right. Thank you, and I wish you well, Judge.
Thank you.
Thank you very much, Judge. Now I'll ask you very, very short questions. One is to do with the stakeholders. How do you manage expectations of stakeholders whose demands may be unrealistic?
Thank you. I want to talk about one particular stakeholder, the Law Society of Kenya. When I became president of the association, the expectations of the Law Society of Kenya were running parallel with some of the expectations of the judiciary. I reached out to the president of the Law Society of Kenya, Madam Faith, and we agreed to call a meeting. I think that was the very first time that the association was meeting with the Council of the Law Society of Kenya. And in that meeting, we agreed to form a committee of wise men. The Law Society of Kenya nominated Mr. Philip Murgor, Senior Counsel, Madam Judy Tongori, Senior Counsel, may her soul rest in peace, and I believe the third one was Mr. Karori Karioki, also Senior Counsel. On our side as an association, we nominated Judge Fred Ochieng, may his soul rest in peace. We nominated Judge Richard Mwongo, and we nominated Lady Justice Caroline Kendago. Council of Wise Men, and they were able to resolve some of the disputes which we placed before them within 3 hours. I believe that reaching out to that stakeholder to listen to them, and we also listen to them, and then we discuss, is one of the best ways of creating a mutually respectable relationship. So I believe that is one of the ways which we were able to meet the expectations of our stakeholder, the Law Society of Kenya.
Lastly, because I think you've answered part of my question, how can we grow more carrots so that there is enough to go around in the judiciary?
Thank you. Commissioner Olwande talked about this a little bit, part I did not discuss. Recognition. Let us recognize our employees if they perform well. It need not be financial. It's just recognition. A certificate which is printed on A4 paper. That's number one, Commissioner. Number two, which I can also talk about, is acknowledging the performance of these employees, even at the very low level where we are having our staff meetings. You are the best well-groomed staff during the month. You are the most consistent timekeeper. Small things. Thank you.
All right, thank you very much, Asante Sana, Judge.
Thank you, Judge, and thank you, Honorable Commissioners. I think this has been very robust engagement with you, Judge. All the questions the questions that were in my mind have all been asked, and you have answered them. But before we release you, we always give a candidate an opportunity also to engage with us And now the floor is yours, Judge.
Thank you, Chair. One issue which I want to raise relates to the Kenya Revenue Authority. Every time we are invited for interviews, one of the requirements is to get a clearance from the Kenya Revenue Authority, tax clearance certificate. That task has never been easy for any judge or judicial officer. Because when we make those applications, we are told your employer did not remit taxes 2016, 2020, then it becomes a go-round. And I want to thank the Office of the Honorable Chief Registrar. There's a gentleman there called Lawrence Ojala. He's really helped. But sometimes he gets overwhelmed, and that forces us to reach out to Kenya Revenue Authority to get those certificates. I don't know what methodologies the Commission could put in place to save us this agony. Perhaps suggestion which I can give is if the Commission could write directly to the Kenya Revenue Authority, please tell us the tax status of this judge. I remember in my own case, for purposes of this interview, getting that tax certificate was not easy. And the reason you have not paid your taxes, income taxes, employment income tax for 2016, 2017, up to 2019. And you start telling them, you gave me a tax clearance certificate in 2019 when I was going for an interview. Why are you now telling me in 2025 that I have outstanding tax liabilities? It's putting us through a lot of agony. I don't know how the Commission may want to deal with that issue. Yes, so that's the only concern I had.
Thank you.
And now, if you allow me to speak in a little Kiswahili. Nataka kutoa shukrani kwa tume kwa kunipea hii fursa ya kuonyesha ujuzi wangu na uwezo kwa hii interviewi ya kwenda kwa mahakama ya rufaa.
I don't know why people are laughing. Okay, that's why they are laughing.
Yes.
Thank you. Okay. Thank you, Judge. Are you done?
Yes, I just want to thank you for giving me this opportunity. I don't take it for granted. I know the task which you are undertaking is not easy. For most of us in our ages, even our doctors would not recommend that we do this type of sitting from morning to evening, a whole week. But I pray to God to give you good health and also Godspeed in this enterprise.
Thank you. Thank you very much, Judge, for even the feedback about KRI. We normally engage, and I think we can even call them here and engage them on that aspect of the taxes that are paid directly from our salaries to KRI from the consolidated fund. That's a matter we have noted to take it forward so that we do not have to stress our judges and magistrates when they have to come for an interview. Other than that, it's just to wish you all the best and thank you for your courage. I remember you stood very firmly when you were the president of KMJA to defend the independence of the judiciary. And for that, we are very, very grateful. We wish you all the best in this interview, as you have reckoned. It's a very competitive process, And we really want to get the best out of the candidates, so we are not even managing the time properly. So we are always apologizing to candidates for keeping them waiting.
Okay.
So all the best, keep up the good work, keep up the spirit, and keep up the energy of serving Kenyans
Oh,
to
thank
the
you.
best of your ability.
Thank you.
Yeah, we'll get in touch with you when we complete the exercise.
Thank you. Mahojiano. Thank you. Thank you.